earnestly seek to find a rightful balance of both mercy and justice for each petitioner. Our task is to serve the people of Florida. That includes both those requesting clemency and those impacted by the wrongdoings that make clemency necessary. Hear our prayer. We ask for comfort for those who are hurting and courage for those who are nervous. We ask for a generous mercy for those in your divine favor, and for unadorned justice for those who are not ready for the mercies that this board can provide. May the trembling voices be calmed by the steadfast assurance that there is a master plan, a plan that builds a lasting good for every soul. Bless now, O God, that true peace may rule in all the communities of Florida. This is our prayer. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. For those of you here today who may be unfamiliar with the clemency process, let me first explain how the process works. The Florida Rules of Executive Clemency provide 6 types of clemency relief: pardons, commutation of sentence, restoration of firearm authority, restoration of civil rights, remission of fines and forfeitures, and restoration of alien status. This is a board of clemency. Okay, there's no law we're following. The law had already been followed by the judges. So we get to make our decisions based on our own beliefs. So there's no, because you did X or did Y, because it's a certain amount of time and all these things, there's no, we're under no obligation to change.
Winston Carson James is not here.
I deny restoration of civil rights.
28, Ronald W. Jenkins is not here.
I deny restoration of civil rights.
29, Marie M. Jones is not here.
I deny restoration of civil rights.
Number 30, Norman Levin is not here.
I deny restoration of civil rights.
31, Carlos Bernard Lewis is not here.
I deny restoration of civil rights.
32,
the clemency process prior to Amendment 4 being approved and taking effect. Restoration of civil rights in Florida was a form of executive clemency. The governor and cabinet collectively would determine, and there are many forms of clemency, but civil rights restoration, which included voting eligibility, service eligibility to serve on a jury, right to hold public office, that was a function of whether the governor and cabinet decided to purely discretionary restore those rights. So during that process, and over the course of the past 8 years, for instance, under Governor Scott, not many more than a few thousand people regained their civil rights, including the right to vote. That was a dramatic downturn in terms of comparing to other rules and administrations. A small fraction of what occurred before, and then it's changed over time. So because so relatively few people regained their civil rights over the course of the past 8 years, the 2 terms under Governor Scott and the cabinet, Amendment 4 advanced. In the case of Amendment 4, the language was drafted in such a way that at least arguably it could be interpreted in different ways, or it was vague as to process. Now, it was complicated by the fact that the legislature actually changed the language of the petition that voters approved. The language of the petition said, restoration upon completion of all terms of sentence, including parole or probation. That one sequence. What legislative bill drafting did is it, in both the House and the Senate, it inserted a comma after completion of all terms of sentence. So in other words, there's a pause there. The arguably what was an essential modifier, that is, including parole or probation, now becomes a subordinate clause. So in effect, what happened, arguably, is you take a statement upon completion of sentence as defined there, meaning including parole or probation. Doesn't say anything about fines, fees, or costs. But now, if you put a comma in there, it says, upon completion of all terms of sentence, pause, including but not limited to parole, probation, fines, fees, costs, whatever.
Scarcity is true. I mean, there is only so much money, and I think that the legislative body has to make those decisions, and I leave it to them. I think that one of the decisions they made a while back was to try to make the criminal justice system self-financing, which is where you got a lot of these fines and court costs. That was a legislative decision, and I'm going to follow it because that was their decision. Now, if you're asking me, do I think it was a wise decision? No, I don't think it was. I understand the public policy. It would be nice, you know, it's the same common market or, you know, market-based economy where, you know, the patient has to pay for his medical care. Okay. But candidly, we as a society are not comfortable with that because we're not, okay, so the rich man gets to live and the poor man dies. Well, we've decided that we're not comfortable with that. When you get to the criminal justice system, once you put somebody incarcerated, their earning potential drops off astronomically. So if they have any at all. So he's never going to earn again. So how the heck is he going to pay for his own incarceration? Of course he's not. And so that's the flaw in the system as they've set it up.
Even when the felons get out of jail, reality is they're not going to be able to find a job. Some of these court costs we're looking at are 6 figures, and I think people have this perception that, you know, we're talking about $2,000 and $3,000. A drug trafficking charge is $50,000, and then it accrues interest over time from the day it's assessed. So you're looking out, if they do 10 years, that debt is now $75,000. And then when they get out and re-enter society, try to find a place to live, and they're having to choose between paying rent, putting food on the table, it's a no-brainer. They're not going to pay their court costs. But I try, again, I tell everybody I pay minimum wage. I pay someone $12 just to collect $5 a month. But if, again, at that rate, the ability to pay off a $100,000 fine, they will be paying, and they're not eligible to vote until they pay that off. They'll be paying that their entire life. So the situation, unfortunately, again, puts the humanitarian and the social, economical issue at the table. Only if you can afford, the rich, again, if you can't afford to pay, you'll be able to restore your rights. But if you can't afford to pay, you essentially have lost your rights. And I think that is a big social issue. Actually, the clerks are going to be impacted, I think, the greatest, because, again, our funding mechanism, our funding model is based on, we get funding based on the amount that we collect. In the current language, in the current bill as it's stated, and it's my understanding the governor hadn't actually signed it yet, but it gives the felons an opportunity to petition the courts to waive their court costs. So it's a struggle to me as, you know, as a clerk, but I do agree, I do support Amendment 4, but I oppose the implementation of the process because I do need those funds to run my office. I have 140 employees, so I have a responsibility to them as well. However, they're not, we know, we have the data right now statewide. We have a 9% collection rate on our felony and our criminal cases. Looking at both sides of the argument, we have not been able to collect from those case types anyways. But I also believe, as Gwen the citizen, again, you shouldn't allow that one incident to define the rest of a person's life. You give them an opportunity to reintegrate into society, and I think everyone should have a voice in their government. So I don't want to deny them the opportunity for representation just because they can't afford a financial obligation. It's not to actually go on record, but it's just because there's just so many different variables that has to be considered in discussion. And I don't think, they did the appropriate research in the beginning when we got the language on the ballot. And I don't think the appropriate the parties necessary was at the table. It was in a rush to get it on the ballot. So a lot of things were overlooked that unfortunately now we're having to go back in hindsight. So it is a very complex issue.
20 years ago, you could go to the Florida Press Association building in Tallahassee, Florida, and on all 3 floors you would have very vibrant, well-staffed bureaus for all of the major newspapers in the state. You would also have various radio networks. You would have TV stations that had presence there from major markets in the state. Maybe not a whole bunch during the year in general, but during the legislative session, that'd be a humming place. Dozens and dozens of reporters from all over Florida would be there to cover everything the legislature did and what those ramifications would be. As we have seen the business model of journalism, especially print journalism, change dramatically, we have also seen broadcast change as more and more TV and radio outlets, driven primarily by things like focus groups, consultants, determine that most people don't want to hear about state government news. That's boring. And so if you want to economize in your news operation, focus more on local tragedy and focus more on national politics, particularly presidential politics, because that's where the eyeballs and the earlobes and the minds of your viewers and your listeners and your readers are going to be. State government stuff, by and large, doesn't poll well. And so we've seen media shrink. Go to the Capitol Press Association today, and you can walk down halls that reverberate to the sound of your footsteps because there ain't nobody there. It's very sad, but people can't learn what they aren't being told. And they won't be told unless there's a media presence to fill in those gaps for you. Mm-hmm. Well, particularly with Amendment 4, since you brought that up, there wasn't that much discussion at the legislative level. The implementing bill, which leveraged all of these conditions onto Amendment 4, making sure that people had to go through all kinds of hoops to pay off fines and fees and whatever else may be a fiscal consideration before they would be eligible to apply for restoration of their voting rights. Didn't take up much time in the legislature. The committee meetings on it moved pretty quickly. The legislature didn't take much testimony from people. It was fast-tracked. It truly was, which is not unusual and certainly is not illegal or unethical, but this is what happened. It went through the leadership, it hit the committee process, it went onto the floor, it was enacted, the governor subsequently signed it, and people were blinking their eyes going, what happened? I thought this was a done deal. This was a enabling piece of constitutional legislation. And it wasn't. And now they're starting to hear stories like we're doing and many other media outlets of people saying, hey, I'm trying to get registered to vote, but there's all these conditions that I have to meet before I can do that. And people go, what? I thought this was already happening.
Members of the community. I think that getting people their rights back and allowing them to become active and civically responsible members of our community is a good thing. So I think that in that sense, getting them to be able to have the powers and to assimilate back into culture, good idea. So as an ideological, I don't think that necessarily continuing to put things into the Florida Constitution is the best way. Mm-hmm. We've seen some odd things. I think, as I said earlier, I believe in the republic form of government. I don't think the Constitution should have a lot of specifics. Mm-hmm. It should be a guiding principles kind of a document. Mm-hmm. I think it would have been good to be able to do it through the legislative system, because we wouldn't have a lot of this ambiguity. They could have fixed it on the front end instead of now we're having, how does this fit in the framework of the rest of the Constitution and the rest of the Florida statute? It trumps the rest of the statute, so we're clear about that. You know, we're already starting to try to figure out, for instance, some of the definitions. What does it mean to be a sex offense or a homicide? Mm-hmm. What does it mean to be the end of sentence? Legislature would have sniffed that out, hopefully, when they were drafting it, and could have if you see most statutes, the whole first section of it is a definition section where they lay out, and this is what we mean by drugs, and this is what we mean by a homicide, and this is what we mean by a sex offense. And they could have done that in whole cloth, instead of now we're having to look around and figure it out. And it's going to take us 2 or 3 more years, I think, until the Florida Supreme Court does the construction and makes a decision on what they think they meant. And I don't know what that'll be. I mean, that's 7 people who are sitting on the Florida Supreme Court right now who will, they will have to somehow, using their brains, understand what, like we said, I don't know what the numbers are, 30, 40 million people thought. And some of those people didn't know what they thought. Some people just checked the box yes on everything. Some people checked no on everything. Mm-hmm. Some people didn't,
So same deal here with Amendment 4, what would seem to be a pretty straightforward situation from the voter's viewpoint. Oh, okay, you fulfilled terms of your sentence. The judge said you have 3 years in prison and 2 years probation. Okay, you go through that. You paid your debt to society. You should get your voting rights back, or have that ability. And the legislators say, oh, no. What the voters meant was this and that and these and those, and kind of all this second guessing. It's pretty common, and especially in a state that does not have the initiative for legislation, but only constitutional matters. We're not California, where voters can change the laws. We are Florida, where only the Constitution can be changed. And once again, the Florida legislature has decided, what voters really want is that it's going to be very, 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 very tough for them to change the Constitution.
Well, State Attorney Campbell's observations, are valid to some extent. There was no indication that the legislature intended to weigh in. Legislature had opportunity, and that is, they couldn't legislate clemency or voting eligibility. What the legislature could have done over the years, many years, is to pass a joint resolution to change the Constitution along these lines. Legislature did not indicate any intent or willingness to do that. So while it's hypothetically possible, had the legislature done that and addressed the problem, there wouldn't have been a citizens initiative. Rather than presume that I know what 5 million voters intended, it is reasonable to conclude one thing, that voters didn't approve Amendment 4 to make it more difficult for former offenders to vote. And in some key respects, that's what's happened. Now, back to Governor Scott and the cabinet, when so relatively few people regained their civil rights. Restitution was required, but not payment of fines, fees, and costs. So here's an irony. Arguably the reason, or one of the key reasons why there was a citizens initiative, a ballot initiative that led to Amendment 4, was because of the lack, essentially the lack of restoration of voting and eligibility and other civil rights. Even then, Governor Scott and the cabinet didn't require payment of fines, fees, and costs. It was possible for the legislature to proceed as, even though it didn't do it frequently, as Governor Scott and the cabinet proceeded, not require payment of fines and fees and costs. Maybe restitution, but at least not fines and fees and costs. Now that wouldn't have meant that those fines and fees and costs would be eliminated. They would have been just pending, as it would be anyway, people paying them at some point. They just wouldn't, it wouldn't have been a quid pro quo for voting.
Court costs. We have some of the highest court costs in the country in the state of Florida. So I think to start the criminal justice reform process, we might want to go reevaluate how these costs are determined through legislation. We know we have a lot of reform, a lot of things we need to reevaluate. For instance, when a felon is released, they don't have, I guess the misperception, a lot of misperception is that they get this summary order saying you must now do X, Y, Z, and a regular citizen, an educated person, is hard to navigate some of our processes. So just imagine. And then, I've had a lot of people have come to me and say, well, clerk, can you give us a list of all the felons? And again, that's the education. I have court records, but I only have the court records in Leon County. We don't have court records for every county, and then even there's a section, it's my understanding, on the voter's application you have to affirm that you don't have felonies in other states. And so it's not even just a county to county or statewide issue, it's a national issue. But we are working with FDLE on a project right now, criminal justice data exchange. So we have a concept in place. Again, some of this stuff takes time, so we're a little ahead of the curve in the state of Florida. But again, it just goes back to educating the public, educating the advocacy group as to, what is the real law, and not lean into, interpretation based on what side of the table you're sitting on. And the best thing about Amendment 4, it made the legislature aware of some of the inadequacies in the system. So we now are talking about those. So it brought about the discussion or the conversation, which is always, a starting point, but it's positive because we now identified some of our weaknesses and gaps in this process that needs to be addressed.
I don't think that I think the criminal justice system is always going to operate in a deficit. So, you get people who talk about the prison justice system or the criminal justice system, and it's kind of like the industrial military complex. That the argument. To me, I don't think at least my experience, I don't want to see more victims. I think if you work with victims, I work for my victims. That's why I do what I do. I don't want to see more victims. That's where you have to have an educated legislature or whoever's making the decision, government, because your choice is, do I want to continue to shackle this person with financial burdens that they will never meet, which I don't think works out well, because you don't get, all you're doing is continue to disenfranchise. So now I'm out of prison and I owe $20,000. And I can't get a driver's license until I pay the $20,000 because they suspended my driver's license because I haven't paid my court costs and fines. But we do need to move the system from a system where they are totally crippled by this debt that the debt itself stops their ability to earn to pay it off. And so that's where I think that we need to set up systems where it allows them to be gainfully employed. When I get back to case management and things, we need to get them out. There are jobs out there. There really are right now in our community, lots and lots and lots of jobs. And I mean, I could take you to the places right now. We need to be able to get those people in there working so that they can earn it. And then if they can pay it back, great. And hopefully they become productive and once again and go that way. But when they walk out there and they've got this debt, and the debt keeps them from going able to take these jobs, and the debt keeps them from being able to, and so that they just decide to go and start robbing liquor stores again, well then that's not, we've taken a step backwards. So,
but we will have to kind of reinvent the model as we go, build the airplane as we're flying it. I have heard it referred to figure out how do we pay people for the content that they generate, which is only fair, but at the same time not fall into these rabbit holes where, okay, your job is just to generate click-throughs and advertising revenue. How do we do that? I think we have an entire journalistic universe that's working on that one right now. No answers yet. I hope they come soon. We can't keep shrinking the basis of professional journalism indefinitely without, again, everybody falling into their respective rabbit holes.
It was a contentious process, even though arguably shouldn't be a partisan issue. The legislation was approved largely along party lines. And now it's before the federal district court in North Florida. I think right now this process is what we've been observing in terms of many issues. And I think that the expectation, increasingly so, is that the courts will weigh in. Grassroots voices surrounding it to attempt to advance it raised awareness about some of these issues. There's even well-placed opinion editorials, columns. That helps, but it doesn't reach the full extent of the population. So, and now some of the challenges relating to the legislation, again, the one point I raised with you, to the best of my knowledge, I'm the only one that's raised it. But I've raised it before committees, I've raised it in columns, I may, as I said, file an amicus brief to at least flag the issue for the court's consideration. So, and it wouldn't necessarily be that even a well-informed federal judge would know, or Florida Supreme Court justices, because that's not the executive branch. So it's an inherent challenge on a range of issues, not just these, but this is an example of them. It will just take continuing emphasis upon getting the facts right. And it doesn't guarantee that therefore you'll have the right outcome, but at least the facts have to be right. And it's unclear that we've reached that point yet.